The grounds for divorce in Florida are not required. In other words, you don't have to have a necessary reason to divorce him. You can wake up and just say, I really hate him. And that's simply enough in the state of Florida. In the state of Florida, the presumption is that all assets are going to be divided 50-50. There are circumstances where the assets are not distributed equally, but that is a very specialized situation where we make arguments. Potentially, it may be non-marital. Some portion of it may have been owned prior to the marriage. One party may have contributed more to the development or the particular investment. And in that respect, we will divide the assets differently, either equally or unequally, depending on the circumstances. Alimony in the state of Florida has changed dramatically. The laws in the state of Florida have essentially done away with permanent alimony. So now we have a statutory guideline which determines what you're entitled to and for what period of time. We have different types of alimony. We have durational, which is for some period of time. We have rehabilitative, if you're going to need to be educated in order to go back out into the world and live financially independently. We have bridged the gap, which is transitional alimony, which is what you would need to kind of reestablish yourself outside of the marriage. So in the state of Florida, they're going to be looking at the significant disparity in income. It's not just based on what your needs are, it's also based on what the ability of the other person is to contribute without living under a bridge. In the state of Florida, alimony is not necessarily awarded on a regular basis. I think the courts are more conservative now in terms of awarding alimony. I think the courts are more inclined to require that both parties go out and support their own needs. However, in situations where you have a stay-at-home mom that has not been employed and has not been educated in any way, that's probably a sure bet for alimony. The basis for custody in the state of Florida is, what you have to understand first, is the presumption is shared parental responsibility. What that means is every major decision is made jointly. There are circumstances where the court will award one or the other parent the ultimate decision making as to major issues, but those are rare and they're far apart in most instances. In the state of Florida, there's a presumption that both parents are going to have equal time sharing. There are some limited circumstances that we can litigate when we think that there is some risk for the children, and there's some other issues that the court will consider in not awarding 50-50 custody. If you have any questions about divorce, whether it's the grounds for divorce, the distribution of assets, or alimony and what circumstances that you may be awarded alimony or not, contact Monarch Law, and we'll be happy to answer all of your questions.